The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here today, this morning, for the submission of 3 separate cases. The case of State of Iowa versus Anthony Mong is hereby submitted without oral argument. And we will begin oral arguments today with the case of State of Iowa versus Benjamin Trane. Mr. Parrish, are you ready? And Mr. Buller? Okay, Mr. Parrish, you may begin.
Chief Justice Christensen, and may it please the court, Mr. Buller. In the original appeal, you found that the district court judge abused its discretion by not conducting a 5.412 hearing, and also commented on the court's denial of the 412 ruling without hearing evidence. This court has never strayed from the proposition in Baker that false allegations of sexual activity is not sexual behavior, because such statements fall both outside the letter and the spirit of the Rape Shield Law. The unique aspect of Mr. Trane's case is that the district court utilized testimony that would not have been available had the trial conducted the original 412 hearing as required by Rule 5.412. The district court's ruling is not only complicated by its flawed analysis, but also by the consistent unfairness of the district court judge, nod of favoritism, and its lack of impartiality. In our brief, we point out those issues for you, and it started from the first encounter with the court. Granted, as a longtime practitioner in Iowa and often trying complex, high-profile, and controversial cases, it is important to develop a keen sixth sense of whether the court is upset with the nature of your case, your client, or with me as counsel. It's important to become skilled in identifying the problem and making a distinction of the specific order to protect the record for appellate review. When you identify all 3 at one time, your plate is pretty full. I am confident as you review the record in this case, it will give you a similar level of discomfort that both my client and I felt. I don't believe it is necessary for the court to reach the issue of recusal to reverse. It is important to let judges know that they must avoid even the appearance of favoritism so that the courts remain respected, reliable forms for justice. In 2 cases, the state argues that this case is not ready for argument for the Supreme Court, but your specific directive indicated on a remand, much like in Plain, a case like this could come back under what we call the modern rule of appellate review. The 2 cases that the state quotes are cases, one involving a deferred sentence, and we all are aware that deferred sentences, you don't get a shot at coming up on appeal unless something goes eerily wrong in district court. The second case they do is an interlocutory appeal, and in that case they cite where in a motion for new trial, I believe it's a Coughlin case, in the motion for new trial, the defendant wanted to appeal at that juncture.
I'm not personally so concerned about the appellate jurisdiction. I'd like to move back to the main point here, which is, I think as you put it, maybe reading the remand hearing gives one a sense of discomfort, but it's a substantial evidence standard of review. And what is your best case for the position that we could set aside the judge's determination that essentially KS was credible and the Wolocks were not?
First of all, I think, Justice Mansfield, you have to go back to where this case would have been structured at the original time it was presented, and that would have been prior to the time any evidence would have been presented at trial. So if you add in the factor, because you're sent back for a rather thin, focused hearing. The 412 hearing is for the defendant, Mr. Trane, to present the Wolocks. You remember there was a phone call made, and when this phone call was made, The court said that's not sufficient because that's speculative, because the Wolacks told the original trial lawyer in the case where she made a professional statement that, look, this is false. This did not happen. So the question is, we have to start where the court would have been had it not denied the original 412 hearing.
I guess why? Why shouldn't the district court have done what it did here in trying to get all of the information that it could? I mean, I don't read our 2019 ruling as putting any sort of guardrails on the district court.
Guardrails on it, but the guardrails are put on by Rule 412. And 412 says you see whether or not there was a false allegation. And that restricts you to those statements. And I'm not saying KS should not have come in and made statements. But when you move into the physical abuse part, you move into the other parts, and you use the analysis that the district court used under this cloud. I'm sorry. Well, first of all, it was asked because the questions were compounded. And the questions were compounded. I do know what it means. When you ask a question, you expect to get a particular answer, but the physical allegation had been there from the beginning because it goes back to when she first went down as a student to Midwest Academy. She complained after her parents, her adopted parents, put her there to both the physical and what she called was a sexual abuse against them. But again, as you also pointed out in your opinion, to go back to the original question, this information was valuable because you raised in your first opinion whether or not it was a question of if she rebelled against authority, and that's why she would make these allegations. To go back to Justice Manfield's question, there are a few things that are at play here. First of all, the bringing of the physical evidence, whether the door was open or not, is not a factor under 412 to be considered. Whether it can be considered for credibility or not, you may change the rules, Justice McDermott, after the fact. So the point is you can't change the rules after the fact. The plaintiffs have to know and the parties have to know in advance that you can go into all these wide-ranging issues to get what we call credibility issues. But let's look at these adoptive parents. One has a master's degree. Sure, absolutely.
Typically is the false allegation at issue, and when was it made?
The false allegation was made when KS went to Midwest Academy in 2016, I believe, it could be 2015, one of those dates. And when she was first there, she made allegations that the Wolacks had abused her, sexually abused her and physically abused her when she was living in their home from age 7 to age when she went to the Midwest Academy.
If the allegations of abuse against the Wolacks, it seems like at the time the state was involved, that it really wasn't clear what the allegation of abuse was. Does that matter?
It does matter because the district court judge used the fact that Ms. Wolack did not know what Mr. Trane was accused of as a factor to find Ms. Wolack not credible.
I mean, she didn't know what KS had accused her of at the time they were being investigated by DHS in their home state. So does that matter that it's a false allegation of something, but they didn't know what it was?
Some idea, because you recall when Wisconsin comes in to do their investigation, they interview KS at the school, they interview at home, they advise the adopted parents to put up a camera to protect themselves within a week of when she's transferred to Midwest Academy. So
She says she didn't actually tell DHS anything. She tried to be quiet. She didn't disclose anything. And she says, quote, "I don't believe I actually said anything." So it was reported to DHS, but it's not clear to me what the allegation was.
I would agree that it was not clear, but I don't agree with the fact she said she didn't tell them anything, because she says she tells them about the arm being broken, but didn't tell them how it was being broken, whether it was on a horseback, or she later testified the adoptive father pushed her down the steps. The specific allegations denied by both parents is that they never abused her sexually, They never abused her physically, and neither did they observe anything by the other party, the spouse, where there was any type of abuse.
Really difficult. They say they didn't do it. Everybody knows proving a negative is so hard. But would you agree with me in a situation like this? I mean, there's allegations of abuse perpetrated upon KS by more than one person. But my point is, in the world of child welfare, would you agree with me, oftentimes children are re-victimized over and over and have significant trauma? Won't it get to the point where the judge simply has to base it on credibility?
I think, Chief Justice Christensen, the problem is you have to take the 412 hearing if you're going to give it value. If you want to say, let's have a mini trial every time we do a 412 hearing, that's a whole different ballgame. But this judge made the initial mistake by not giving the 412 hearing or delaying it, or it could have been the lawyer's mistake. The problem is, of course, there are situations where there's misdiagnosis. I mean, if you want to go by what's in the paper, but in this case, she makes the same allegations beginning when she's 3 years old about the camera being set up in each of these allegations. Not one single instance comes forward where any photograph or any type of abuse or any record of any abuse is introduced in the courtroom. What you have is two teachers. The adopted dad taught for 15 years. The mother had a master's in education. And they took these children over because they were in a terrible situation. The parental rights had been terminated. Once they were terminated, obviously the next step is to see, can you find a family member, someone who would care for them? And until she got to Midwest Academy, there was not one allegation, Justice McDonald, to go back to your point, that she'd made against these parents. Now, because she holds back on making those allegations, does that give her credibility? If you do that, you change the whole rules of the game when it comes to 412 hearings. The 412 hearing is to do one thing: see if there is a false allegation. Use those factors in there, whether it's introduced in terms of across-the-board testimony and other factors. But if the court's position is, well, we just have to look at what took place within the setting of that hearing, then you cannot, which I invited earlier, look at that without the recusal issue in play here.
The gist of my question is I was concerned about how this would actually play out at trial. So in a typical prior false allegation case, it's very clear. You have somebody make an allegation in the past, it's very clear, it's proven to be false. So in this case, the allegation is what? At some point, Wisconsin investigated this family. None of the family members are clear why or what the name. I mean, they all testify to it at least, that they didn't know what was going on. DHS said, put a camera in your house. So that comes into evidence. What does that prove? And
That's a fair question, but the response is, how would it play out at trial? Well, you had an example of his opinion. That's how it plays out at trial. It's not a 412 hearing. So if this courts decide, well, we're not going to have a normal 412 hearing, we're just going to have a mini trial every time this happens, then you really are changing the rules to the 412 hearing. If you'd had the 412 hearing and the Warlocks had been available to testify and they'd come down to testify, you'd get what's meant by a full 412 hearing. How those factors play at a trial is a credibility question for the jury. It's not a credibility question for a judge at a 412 hearing. You send it back with the direction that he decide based upon what he heard. And did he give them a fair hearing within the context of his background on this case? You cannot say that he did that. And go back to your point, Justice Mansfield, yes, you might feel a level of discomfort, but a level of discomfort also goes to whether or not there was fairness in the assessment. But you can also review the word-by-word ruling of his hearing of how he decides the Warlocks have credibility, then they don't have credibility based upon the fact they can't remember details. But yet, KS, who now has followed and tracked this case at age 22, she then can say, well, yeah, I remember this, and these are the factors that I want you to look at, but yet none of this evidence comes in, but the court gives her credit for that evidence. So it's just like the Justice McDonald, you talk about the issue of, well, they make these complaints to the Wisconsin DHS. DHS came out and investigated. It was their testimony that DHS told them to put the cameras up. Within a week, she was down at Midwest Academy. So the question is, how do you ultimately assess credibility? Maybe you can assess it in this case without looking at who the fact finder was and who the judge was. But I think the danger point here is if you create rules for 412 and create many trials, that was not the purpose of the Rule 412. If credible people, the adopted parents, walk into a courtroom and said, this never happened, the statements are false, we put her in the home because she was a runaway and had a history of difficulty, this is what we thought was in her best interest. And then she makes those allegations, just like you said in your opinion, maybe she has some issue with authority figures, and it did play out. Thank you.
May it please the court. This is one of those cases that comes down to fundamentals of litigation and a couple of principles that decide all of our appellate cases. First, the fact finder determines credibility. Second, burdens of proof matter. And third, standards of review matter. If you apply those principles to this case, the district court must be affirmed because we have district courts in order to determine credibility, and that's exactly what the district court judge did here. This was a case where witnesses gave versions of events that are just utterly irreconcilable. That's what happens in our trial court sometimes. So the district court judge was tasked with following this court's remand order to decide whether the defendant had met his burden of proof, not the state's, the defendant's burden of proof, to prove by a preponderance of the evidence that the allegations were false. The district court's ruling is long, it's detailed. It walks through really a window into how the judge was looking at this case because there were pluses and minuses on both sides of the ledger in determining credibility here. That's not uncommon. That's what juries and district court judges do every day in our courtrooms. The district court judge had to decide who is more credible among these witnesses or decide if they were equally credible, which is not the route the court went down. The court instead decided that KS's testimony was more credible than that of the Wallachs, and there are reasons given in that ruling. What Mr. Parrish wants...
Start to read the reasons, I get somewhat troubled, Mr. Buller. For example, one of the points that's made is that Mr. Wallach was asked sort of conclusory questions on direct, and he answered them with denials. And I think it's fair to say that KS was asked conclusory questions on direct, and she gave conclusory confirmation. So why is the form of questioning and answers held against Mr. Wallach and not against KS?
With that characterization of the record, I do think the questioning of KS and Mr. Wallach was substantially different. The court's comment in its ruling that counsel really led Mr. Wallach through his testimony is based on the fact that Mr. Wallach essentially showed up and said, I don't know what I'm being accused of, but whatever it is, I didn't do it. Obviously, it's relevant for a fact finder, whether it's a jury or a judge, to look at that testimony and find it not credible. This is one of those cases where you look at the cold record and all this court has is part of the story. This was a highly charged hearing. I think everyone in the room knows that Mr. Parrish is a tough lawyer that asks tough questions on cross-examination. You hear the district court judge comment on some of that in the court's ruling, but if you're just looking at the black and white text, you don't see that. That's because when all you look at is a transcript of the case, you can't make the same credibility determinations that the district court did. Mr. Wallach's testimony was so incredible, so unbelievable that I chose not to cross-examine him. And it's not because I couldn't think of any questions, it's because he wasn't believable when he testified. I made that assessment as a trial lawyer, and I think the district court made a similar assessment in its ruling when the court found that based on his appearance in court, his demeanor, his candor, his credibility, this was not a witness that should be believed. That's why we have district courts. The role of the appellate court is not to second guess the credibility findings of the district court, because if that were the case, why do we have a trial judge in the first place? I can agree that the window into the district court judge's mind that you see in the ruling might make you think, I might have said that differently, or I might have weighed the evidence differently. That's probably true of every jury trial and every bench trial that's happened in this state in its history. A lot of evidence can have two different inferences drawn from it. Your question, Justice Mansfield, suggests that perhaps you would have drawn the other inference from that testimony or found that it didn't affect your credibility assessment of the case. That's not the question before the court. The question before the court is dictated by the standard of review. Viewing the evidence in the light most favorable to the state, has the defendant met his burden to prove it is more likely than not that KS made false allegations? The defendant hasn't carried that burden. In fact, he hasn't even gotten to the point where it's 50-50.
Mr. Buller, 5.412, I think Mr. Parrish was arguing that it should have happened earlier, and I think we all admit it's called an opinion by the Supreme Court with remand. That means, yeah, it should have happened back there. So that happened, so we can't undo that. So now we have the real 5.412 hearing, which happened on remand, and then the pretend one that never did happen. How could they have been different? Was the defendant slighted by having it on remand? I'm trying to figure out where Mr. Parrish is going on that. Was an effective 5.412 held, even though it was on remand?
Yes, the defendant got exactly what he was asking for. I will candidly tell the court I'm not sure exactly what more the defendant wants here. There was a brief argument in the district court and objection to KS testifying in the first place. I found that very unusual. I've handled a number of rape shield hearings in my career. It is typical for the witness, the victim in the case, to testify, because how else is the district court going to decide the truth or falsity of the allegations? The way a 5.412 hearing typically plays out is that the defendant puts on some evidence, whether it's through affidavit or by live testimony, of someone saying, the victim accused me of something and it isn't true. The state obviously has a chance to respond to that. The most typical response is for the victim then to testify in chambers. The functional equivalent happened here. Because it was during COVID, there wasn't anybody in the courtroom, so we didn't seal the courtroom. We didn't conduct it in chambers. We did it in open court, but it was a 5.412 hearing. There was no difference between what the defendant wanted before this court's 2019 opinion and exactly what this court ordered. There's been some argument today that a 5.412 hearing shouldn't be a mini trial, but that's exactly what the rule sets forward. It requires the district court to make a finding, weigh the evidence, and conduct the analysis set forth based on all relevant evidence presented to it. And that's exactly what happened here. You had the testimony of the two persons who were accused. They said allegations were made of some fairly indeterminate nature. They said whatever the allegations are, we didn't do it. They were asked some leading questions about the allegations. They denied it. KS testified and she said, yeah, I said some of those things at some point along the way, and they were true. And here's why they were true. Here's what my testimony is. And then the judge had to decide who to believe. This is exactly why we have trial judges, to look at witnesses that give irreconcilable testimony and decide who's telling the truth.
Close to State v. Smith, where there are enough inconsistencies that on our review we can set aside the credibility findings?
Bad law, and you don't have to take my word for that. You can look at the court's own opinion in Mathis from last year. Well, Westlaw's flagged that case as disapproving of Smith, but I would suggest to the court it is in fact an overruling. What this court said in Mathis is that there is a critical error in Smith, which is that it doesn't follow the standard of review. That's the exact error that Mr. Parrish is asking the court to make today. Instead of viewing the evidence in the light most favorable to the state, what the defendant wants is for you to view the evidence in the light most favorable to the accused. That's the opposite of the standard of review. Smith has other problems that I won't go too far into because the court discussed those in Mathis when it either overruled or abrogated or disapproved of the case, but it plays on rape myths, and that's a lot of what we see here. There's been a suggestion today that because a victim was sexually assaulted once, she couldn't possibly have been sexually assaulted again. My experience, similar to what the Chief Justice's question alluded to, is that there are a lot of children in our court system who have been failed by multiple parents and multiple institutions. It is not unusual to see a child who's been abused in different placements throughout their life. I don't think it is fair to hold that against KS because this is a girl who, from her own testimony, has been through hell. She's been through a series of terrible circumstances. She's had to come into court and tell some of her darkest secrets to a bunch of strangers, not once, not twice, but now 3 times. She held up to rigorous cross-examination. Tough questions is what the district court calls it. In my motions below, I'm sure the court has seen I describe it as insulting because that's how KS felt on the stand, and that was obvious to everyone in the room. These are tough cases with tough issues that involve the worst days of people's lives. And KS held up to this tough questioning. She answered consistently, she answered credibly, and she answered with candor about things that none of us would want to discuss in open court. That is the basis of the district court's ruling. She was consistent, she was credible, she spoke with candor, and the defendant hasn't offered this court any reason to overturn that ruling. If there are no other questions, I would ask this court to affirm the district court.
Mr. Buller, during the course of and this is raised by Mr. Parrish, during the course of Mr. Wallach's direct examination, you interrupted and said that the court should advise the witness of his Fifth Amendment right. Why didn't you raise that before the proceeding? Why did you interrupt in the middle of Mr. Parrish's question?
Opportunity before, and I didn't think it appropriate for me to contact a defense witness and give that advisory. I had an ethical concern that if I was in the courtroom, he was there under potentially compelled testimony and asked to incriminate himself. I had a concern under my ethical rules about that scenario, and of course the judge then did give him a shortened version of the advisory. It certainly wasn't to intimidate him or anything like that, but I have a concern anytime we're forcing people to come in and talk about what is undoubtedly felony sex abuse, they need to understand their rights. He didn't have counsel appointed to him. Mr. Parrish's job wasn't to look out for Mr. Wallach, it was to look out for Mr. Trane.
Counsel, could you briefly address this jurisdictional issue? Because courts do regularly allow us to appeal from orders. I'd like to hear your thoughts.
I certainly agree there are a lot of notices of appeal filed from a remand order. That doesn't mean that's the correct way to raise the issue. Part of Mr. Parrish's argument is that these are old cases, but I'm not sure that tells the court very much because we all know that in the modern era, motion practice is where these jurisdictional questions are decided. Part of the reason that I suggested retention could be appropriate in this case is to add some clarity to that issue, to give us a clear answer in the case law. My concern in this case in particular is that I don't want a series of unending appeals where Mr. Trane is allowed to avoid justice for 3, 5, or 7 years.
Be something like maybe what we might see in some PCRs. This, though, 5.412, when Mr. Parrish finally got a chance to actually conduct one, it never happened before. So how can, otherwise, are we saying that if we remand something that should have been touched on, it is bulletproof, you can never, ever challenge it?
Petition for an extraordinary writ, you can ask for discretionary review.
Prefer that instead of doing a conditional affirmance with a remand, that we just vacate the decision and order a new trial? Would you rather do that?
But I think the remand order here is unclear. It does suggest that the conviction is affirmed by the district court. That's what the court ordered the district court to do.
I own up to that, and you may get a chance to write appellate opinions too, Mr. Buller. But I do. Isn't it logical to conclude that the condition and sentence became final when on August 12, 2020, when the district court entered the order denying the 5.4112 motion, and at that point, while we had made clear in our opinion we didn't want to hear about other issues in the case, an appeal from that ruling was fair game.
And it's not me that's saying this, it's the legislature's words I'm talking about. Chapter 814 doesn't talk about final judgments for appeal in a criminal case. It's a final judgment of sentence. That is what the legislature has restricted this court's jurisdiction to. Is this a final judgment that happened after the fact? Perhaps, but it's certainly not a final judgment of sentence. And I think that could be a distinction without a difference. That's something the court could say. But under current law, that's an ambiguity that has no answer. And in fact, what you see the district court say in response to our motions is, it looks like the state's right, but I'm worried the Supreme Court meant something else, and that's why the court allowed the defendant to post an appeal bond here.
I think you were getting to it. If the state's position is it's just the improper mode of seeking appellate review, and the defendant could have filed a petition for discretionary review, what's the practical consequence?
Particular case, there might not be a practical consequence, but my concern is broader than just this case. It's not uncommon to see conditional remands, as those of you who've been on the Court of Appeals know. Ellis issues and the motion for new trial are one of those issues that I think perhaps will never go away. We will always have conditional remands asking the district court to rule with the correct standard of review on a motion for new trial. I don't think every single one of those cases should make another trip to the appellate courts. Those defendants shouldn't have double the matter of right appeal rights of other defendants. If there's a live issue, I think they should be able to get into the courtroom by petition for certiorari, by application for discretionary review. But if the only claim is I disagree with the district court and I don't really have any reasons, that's not a good use of this court's appellate jurisdiction. Issues like asking this court to reweigh credibility are not a valid use of the court's resources.
I mean, now you're arguing that we don't have jurisdiction because you happen to believe the appeal is not meritorious. That's a separate point, right? The question is, can we continue to do conditional affirmances and have the defendant then come back and appeal if on remand the district court agrees with its original position? And if you're saying not, then that may be a situation where we shouldn't be doing conditional affirmances anymore, right?
Can the court order a conditional affirmance? Absolutely yes. There are examples in our brief of the court ordering a conditional affirmance and making clear whether that case can return to this court. I would suggest that is a better practice. It gives direction to the district court, and it doesn't leave the judge in the situation the district court was in here, where they were told to affirm the opinion, which is typically the work of an appellate court. This court could say that we remand this case, it is affirmed on condition, and the defendant may seek review by this court again. That would have added clarity here and would have resolved the issue.
In jurisdiction, if we're doing a limited remand for a 5-4-12 hearing, just remand it and retain jurisdiction.
Far enough, that's the language you see the court use. I'm not sure there's a difference between that and the example I gave in terms of practice, but certainly either route would be appropriate.
The defendant has appointed counsel. You have one appellate counsel, you have an appellate defender here who would not be representing the defendant below. How would you handle that?
Come up under the rules of criminal procedure and no one quite knows what to do. It's been handled differently in different districts. We have seen on occasion concurrent appointment where appellate counsel retains their appointment on the case but only for appellate purposes. And then there's an appointment in the district court for purpose of the remand. Unfortunately, I think that's an issue for the state public defender to sort out rather than this court. Thank you. I'd ask the court to affirm.
Thank you, Your Honors. I'd like to turn to Justice Mansfield's question initially that you asked Mr. Bullard. It's kind of like the heart of this case when in the middle of the examination, he tells the judge, who the judge quickly accesses, let's go ahead and give him his Fifth Amendment rights. It was to intimidate him. Just like Chief Justice Christensen asked me, you know, when you let something into the record, you know what the prosecutor is doing at that point. He wanted to stop Mr. Warlock in his track. Now, the other thing is that he makes the argument to this court, which is more like a jury argument, that the reason I didn't cross-examine him is because I want you to think he was a liar. Well, the judge didn't even think that he was a liar. He thought he was telling the truth, but he didn't have a specific recall of details. So those two things tie in together. He wanted to intimidate him. He wanted to frighten him. But remember, this is a case that goes back when this young girl was 7 years old. And go back to your question, Justice McDonald, there are some factors where they advise the DHS from Wisconsin as to what's going on. No charges were filed, no documents were presented, nothing to do this. But yet the district court judge punishes the Warlocks for not being able to recall specifics about what was going on. Common sense tell us, and not to make a common sense argument to this court, since I was the appellate lawyer in the Smith case that the state now says is bad law. But I remember Judge Donaldson writing that opinion in that case and the factors. There are some similar factors, Justice Waterman, in this case, because KS, and not being critical for her, she's a troubled child, was all over the board with every party. But there's a strange similarity that should scare the daylights of people who read the transcript. Every case involved a camera back when she was 3 years old, set on a tripod. Every incident, including the one with the Wolocks, involved a tripod. With Mr. Trane involved a tripod. That's a strange, scary incident. And there's also a long history of her running away and being defiant against authority. And you mentioned that even in your opinion as to why that would be a defense that would be significant. The judge didn't consider, district court judge didn't consider that significant, but it does tie into your argument because in your opinion, you address the 412 hearing. It goes to whether or not this young lady has made these type of allegations against other people. And did she make it against Mr. Trane under these circumstances?
Tripod thing, because there were no pictures and evidence.
Because there's no picture, the similarity of the stories from when she was 3 years old to 7 with her natural parents. Then when she was with another set, it became a tripod. But the tripod was explained by Mr. Wolack or Ms. Wolack in her testimony, being that DHS from Wisconsin advised them to do that because she was such a troubled child. They had some sense of what was going on. Educators don't go out and adopt a troubled child not knowing that they might be in for the run of their lives or the incident of their lives. That gives them credibility too. There was absolutely no credibility given to that aspect of the case. They say cross-examination is the greatest engine ever invented to find the truth. Failure to do cross-examination, maybe the state was afraid of the truth in asking those questions to the Wolocks in that question. But it does not mean that based upon his failure to ask questions, that somehow there is a lack of credibility on Mr. Wolock. And one other factor I would like to conclude with. I think sometimes when we sit on cases, we sit back, and I'm not crazy about that instruction. You don't need any corroboration to have someone I just finished a trial in Mason City on that same issue where my client was acquitted, and you get that instruction. However, at a 412 hearing, we're not dealing with that instruction. At a 412 hearing, corroboration is important. This couple corroborated each other. Yet, if you want to look at that single instruction out there floating around that says, in a sex abuse trial, no corroboration is necessary, where was the corroboration with regard to?
I have a little bit of a bone to pick with you when you said that it's not a trial on a trial, the 412 hearing. I'm looking at the language of, it's called hearing, which as a trial judge, ding, 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 that's my job when I was back there. The court must conduct a hearing in camera to determine, which to me means weigh, if such evidence is admissible. That's got hearing and trial smacked all over it. What do you mean by that? How can that not be considered a mini trial?
Lined in my notes in more detail how he developed it from the from the Baker case, and I think there was a modification of it in another case, where the 412 hearing is to explore the issue of whether or not it was a false allegation. Who's making it? Where were they from? How long did they have the child? What were the circumstances, or what was the relationship? It can't be too far back in time. Those are the factors that I think that you should consider in a 412 hearing, not the ultimate trial where you say, okay, I have all this trial testimony here, and I'm going to bring this in, and I'm going to balance it against everything at the 412 hearing. None of these questions Mr. Trane had an opportunity to cross-examine during the trial under the rubric of a 412 hearing. He's never had his day to explore the 412 hearing in relation to his guilt or innocence. He's only had the opportunity to explore it in relation to his 412 hearing. And a preponderance of the evidence, the lowest standard on the planet, or in this court, or in this jurisdiction, you didn't meet that?
I'm going to do one more question here. You're saying he didn't get his chance. You're saying before a jury. Well, that ain't the jury's job if the judge has already decided that should not come in. So I guess I'm struggling with you saying, I think the court did make a determination. It did do its job, and that's the purpose of a pretrial ruling. So why do you think he should have still got to put that evidence before a jury when we have a court that did do the weighing, albeit it was later? And if he'd have come back and said, yeah, that was false, then of course we'd have had a new trial.
He not only did it later, he did it in an unfair manner. And by analyzing his opinion, it's written all over that this judge was not fair, including the question brought up by Justice Mansfield when these folks had driven down in April of under COVID conditions and testified that he did not find them what you would call credible because they can remember every specific detail of what happened when they were dealing with this child in Wisconsin. So the question I believe that you're posing is, are we entitled to a mini trial? Yes, but are you entitled to have evidence that Mr. Trane never had an opportunity to examine during the course of the trial, remember, at a 412 hearing? So are we going to have a standard of beyond reasonable doubt at the 412 hearing or the clear and convincing evidence? No, the standard is written right into the rule. It's by a preponderance. So all I need is a feather. You know, that's what I tell jurors sometimes. It's something less than that. To even sway it, I need less than 50, a little bit more than 50%. So once you read this record and you balance all of the conduct of the court and the consistent rulings, including the one you brought up, Justice Mansfield, about, yeah, you're going to take the fifth based upon an incident in Wisconsin in 2012 or 2013 that they're still looking for you for, and there's no evidence to present it. That was done for one reason, to scare the daylights out of him. Thank you.
Parrish and Mr. Buller. The case of State versus Trane is hereby submitted. We'll have a brief transition before our next case, which will be Dickey versus Jeremy Hoff and others.